Do you understand that do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions in federal courts?
Yes, ma'am.
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you will be guilty of a felony which may carry a sentence from 1 to 15 years in prison?
Ma'am.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
Yes, ma'am.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Ma'am.
Yes, ma'am.
the right to remain silent and not incriminate yourself,
Yes, ma'am.
Yes, ma'am.
the right to confront witnesses against you,
Yes, ma'am.
Yes.
the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case,
Yes, ma'am.
Yes, ma'am.
the right to the presumption of innocence,
Yes.
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes, ma'am.
Yes.
the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Yes.
Okay. Mr. Rogers, how do you plead to indictment 25 SC 000816 to an aggravated assault and possession of a firearm during the commission of a felony? Mr. Rogers, how do you plead?
Guilty.
Mr. Mender, how do you plead in indictment 25 SC 000816 to the count of reckless conduct?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
Ma'am.
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Yes.
Judge, I believe the facts would bear out at trial that on November 26, 2024 at 41 10th Street in Atlanta, Georgia in Fulton County, that officers responded from the MARTA Police Department to a shots fired called at the MARTA Midtown Station. Upon arrival, officers observed the victim, Mr. Udon Holly, who was bleeding profusely from gunshot wounds to his right and left thigh. MARTA police officers reviewed CCTV video surveillance footage, which captured the events leading to the shooting. It appears that the victim grabbed a cell phone and a charger that belonged to one of the defendants. They attempted to retrieve that cell phone and charger. And one of the defendants, and not the defendants before the court today, Mr. Horn, who's entered a plea, did shoot, in fact, Mr. Holly, the victim. Officers shortly were able to apprehend the juvenile defendants outside of the MARTA station. And so we are recommending for Mr. Rogers to the aggravated assault, 5 years to serve 1 year, for the possession of firearm, 5 years consecutive probation. So for a total of 10 years with 1 year to serve, that Mr. Rogers obtain his GED or enroll in school, that he completes 40 hours community service, and that he participate with At Promise Center or Next Level Boys. We are recommending for Mr. Mender that his case be transferred back to juvenile court. We are reducing the aggravated assault charge to reckless conduct. Mr. Mender did not touch the gun, provide the gun, or shoot the victim in this case.
And tell me, Mr. Rogers, your theory of the case is that the evidence would show that Mr. Rogers was the one who brought the gun to the situation, gave it to Mr. Horn. I mean, the video shows Mr. Horn was the shooter. That I
Correct.
remember very clearly, but it was Mr. Rogers who brought the gun to the situation.
Thank you, Judge. Yes, Mr. Rogers did provide the gun that Mr. Horn used.
Okay. All right. Thank you for that. Ms. Singleton, I appreciate you being here on short notice. What can you tell me about Mr. Rogers' juvenile history?
Mr. Rogers has 2 open cases. He has a loitering and prowling from April the 28th of 2024. That is the date the complaint was filed with the court. That case is still open. And he has a September the 14th, 2024 theft by receiving 2 counts, possession of a handgun by a person under 18, obstruction, possession of a weapon during a crime, and stop sign and yield sign. Both of those cases are scheduled for juvenile court on July the 2nd of this year.
What, in your experience, typically happens with those kinds of cases in the face of today's likely outcome?
I've been in contact with his juvenile court lawyer, Ms. Schimmer, and they were waiting to see what we were going to do here. So initially that was going to be a status date, but I suspect it'll be more of a disposition. Based on the my recent experience with juvenile court in a situation like this is based on the conditions that are being placed on the sentence, supervision by myself, the Promise Center and the services provided there, they're likely to just adopt the same conditions.
Okay. And Mr. Rogers has been in custody for roughly how long? Do we know?
Go ahead.
I'm sorry, on November the 27th of 2024.
Okay, so 7 months-ish we're coming up on.
Right.
Okay,
Right.
got it. And what about Mr. Mender's juvenile history?
He has no history. Your Honor.
Okay, got it. Mr. Francis, we can handle your clients in whatever order you'd like.
Oh, Judge, we'll do Mr. Rogers first. We would ask that you accept the plea as negotiated. His mom is here. Stand up, Mom. And Judge, it is our understanding that since he will be in DJJ, he will serve day for day. So he will not be released until November. My understanding is that he has acclimated well over there as far as school. So that way he will be able to stay in school there. And then we can have a plan for him as he transitions out in November, because that's going to be sort of interesting how that's going to work. And I'll talk to Ms. Hudson about that because that's almost the end of the semester. So,
Right.
But if he could, I guess, finish the semester, maybe take his finals outside,
Right.
then he could transition in January back into a high school.
Sure.
I don't think he'll be able to go back to Washington High. He'll have to go to an alternative high school. Is that correct?
He possibly will have to go to alternative
Right.
school, but because of the deduction, he has a better chance of getting allowed to go back to traditional.
Right.
The reduction, you said?
Yes.
Yes, okay.
The armed robbery would have put him into the alternative school. By that being removed, he has a better chance of going back to traditional.
Okay, one more question for you about both defendants, Ms. Singleton. I forgot to ask, do you have information on how, we'll start with Mr. Rogers, did in DJJ custody?
My understanding is
Well, that took a turn. We wrapped up a pretty involved juvenile plea hearing featuring 2 teenagers, Mr. Jamal Rogers and Mr. Bernard Mender, in front of a well-prepared and composed judge, with all parties striving to balance accountability with a shot at redemption. The hearing built on a prior session, and this one focused heavily on formalizing the plea deals, confirming understanding of rights, and unpacking the background facts. What stood out here wasn't just the gravity of the charges, but how the court took time to ensure clarity, fairness, and some hope for a future beyond this courtroom. Let's start with the basics. Mr. Rogers pled guilty to aggravated assault and possession of a firearm during the commission of a felony. Mr. Mender, on the other hand, received a significantly lighter treatment. The aggravated assault charge was reduced to reckless conduct, a misdemeanor, and the firearm charge was dropped. The key factor? Mr. Rogers had brought the gun to the scene, handed it off to another individual, Mr. Horn, who already pled out, and that individual was the one who fired it. Neither Rogers nor Minder pulled the trigger, but Rogers' involvement with the firearm escalated things considerably in the eyes of the court and the state. The Assistant District Attorney, Miss Davis, laid out the state's theory clearly. There was a confrontation at the MARTA Midtown Station in Atlanta, stemming from a dispute over a phone and charger. The victim, Mr. Udon Hawley, ended up shot in both thighs. Surveillance video and prompt police response helped clarify the sequence of events. The judge made it a point to confirm that Mr. Rogers brought the weapon and passed it along, making his role instrumental, though indirect. The sentencing recommendations followed accordingly. Mr. Rogers received a 10-year sentence, 1 year to serve in DJJ custody, followed by 5 years of probation. Additional conditions included school enrollment or GED, 40 hours of community service, and engagement with youth support programs like the At Promise Center or Next Level Boys. Mr. Minder's plea outcome involved no jail time and a transfer of his case back to juvenile court, given that he had no prior record and did not touch the weapon. The court also took time to dive into each teen's background. Mr. Rogers, unfortunately, came in with 2 open juvenile cases, one involving possession of a handgun while underage. His juvenile court attorney was waiting to see how this plea would land, and it's likely the pending cases will now be folded into this sentence. Despite the record, his behavior in DJJ custody was reportedly solid, and his attorney noted he'd acclimated well in school. There's a plan to help him finish his semester while in custody and potentially transition back to a traditional high school, possibly even Washington High, where he previously attended. The judge, prosecutors, and defense seemed genuinely interested in setting that transition up for success. Mr. Minder, for his part, had no juvenile history and remained quiet but responsive throughout. The judge acknowledged the difference in conduct and consequences, and the hearing concluded with the court accepting both pleas. It's not every day you see such a layered, thoughtful, juvenile case where the system tries genuinely to balance justice with rehabilitation. And that makes this one worth talking about. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.